Hi there, I'm Michael Jenkins, one of the probate partners at Jenkins & Jenkins. If you're viewing this video, you may find yourself in need of going through probate in San Diego County. Now, for a lot of people, hearing the words probate brings up all kinds of horror stories of the terrible path ahead. Truth be told, with the right legal counsel on your side, going through probate in California doesn't have to be the horror that it's made out to be. With someone who knows their stuff by your side, guiding you every step of the way, it really should just feel like a big hurry up and wait game from your perspective. I found a lot of the anxiety around probate really comes from just not knowing what to expect. In this quick video, let me give you a high-level overview of the San Diego probate court process so that you know what to expect if you are left picking up the pieces. Now, the first step of any probate is, of course, making sure we have to actually go through the probate process at court. Now, in our Probate Roadmap Call, we'll walk through with you what it is you're dealing with to make sure that probate is in fact required for your case. If probate court is required, the first step in any probate is petitioning the court to get someone appointed to actually take charge of the estate and shepherd it through the process. We call that person the executor. You may hear different words for this. You may hear personal representative or administrator. Most people refer to it as an executor, so I'll use that here. They're basically synonyms, though, for the context of this video. Now, the executor is the person that the court appoints to take control of all estate assets and then shepherd them through the remainder of the process. When we file the petition to get an executor named, after filing, it's going to take about 1 to 2 months to get into court to have this person appointed. We detail for the court why they should be appointed. Either they're named in a will, or if there is no will, then they're essentially next of kin and willing to do it. Of course, that's case dependent, but we'll make that argument for the court of why our named person should be appointed as the executor. In the lead up to that hearing, we're going to make sure that we provide all the right legal notices to everybody that's involved, that we publish as required for the court process, and that we check all the boxes to make sure that when we get to court, we don't have any hiccups and we actually have the person in the petition named as the executor or the personal representative. Now, one thing that makes a lot of people nervous about probate court is, I don't want to be the executor because I don't want to have to show up to court. If you hire a law firm to work for you, you do not have to show up to court and stand in front of a judge and testify to anything, okay? That's quite literally the attorney's job. We'll show up to court for you. We take care of all of that. In fact, if you're not in San Diego, don't worry about it. You don't have to be in San Diego for just about any part of the process in most cases. Now, after the initial hearing, we should have the executor appointed. Now we have somebody who can step in and take control of estate assets. That's number 2, or deal with creditors. And it kind of goes together. So once the court says this person can be the executor, that gives them the legal authority to take anything that was in the decedent's name and put it under their control. Okay, it's called marshaling assets. If there's a house involved, the executor can sell the house in this stage, which is just a couple months after the initial petition, not a huge wait time there. If bank accounts need to be claimed, we go to the financial institution, claim the account, and we start marshaling everything into an estate account that's under the control of the executor. If creditors come forward, we deal with the creditors during this part of the probate process. How long it takes varies quite a bit from case to case, but at a minimum, we have to wait 4 months after we have an executor appointed before we can do anything else. And that's largely due to these guys, the creditors. This is a time where anyone who is going to come forward as a creditor has their time to do so. It's sort of a speak now or forever hold your peace part of the probate process. So there's a big waiting period here where we have creditors coming forward, but in reality, we're working on other things in the background. So collecting assets, especially if a house is going to be sold, it's going to take a few months, generally speaking, anyway. In some cases, 4 months is more than enough, and we've collected all the assets, dealt with any last bills that have come up, or any creditors that have come out of the woodwork, and now we're ready to move into the next phase. In others, it may take a little bit longer to work through, but again, that's very case dependent based on what it is that we're dealing with. Running at the same time here is going to be the third general phase of probate, and that's our inventory phase. This is where we're going to write a petition to the court and we're going to tell the judge what we found in the estate and what the appraised value of all the assets are. There's someone called a probate referee that's an independent third party involved in this phase, and they actually inventory the estate property so that there's a neutral third party telling the judge what the values are. Now again, these phases largely will run together with one another. In some cases, 4 months is enough. In other cases, it'll go on a little bit longer, just depending on exactly what we're dealing with. After at least 4 months has passed since the executor is appointed, and we're confident that all assets have been collected and marshaled into the estate account, we've dealt with all the creditors, we've made an inventory and appraisal to the court, then we can move into the final phase of the probate process. That is distribution. What happens at this phase, we write a petition to the court again to tell the judge everything that we've done during the probate process. And our ultimate ask here is for the judge to approve everything we've done and approve our proposed distribution. When we file this petition, it's going to be one of the longest waiting periods. About 4 to 6 months is average in San Diego Probate Court at the time of this video. There's a good variability there, just depending on the volume of cases, but usually it's the longest waiting time during the process. It's never fun waiting, but the good news is this is the final hearing for most routine probates. At that final hearing, we get an order from the judge that says, "Good job, executor. You did everything just right. I agree with your distribution plan because it's in accordance to the will, or it's in accordance to intestacy rules, generic probate code, so I'm going to sign your order." And when we get that signed distribution order, that's when the executor can write their inheritance checks to whoever it is that's inheriting. Now, all told together, on an average probate in San Diego County, this is going to be 12 to 15 months. Can it go quicker? Yes. There's a chance that it goes in about 9 or 10 months in some cases if everything just goes perfect. But I always tell our clients, let's prep for 12 to 15 months mentally because that's the average, and that's a lot to do with just waiting to get into court. And if we get it done quicker, that's fantastic. Now the key here is you want somebody who's going to make sure they shepherd you through this process without ever incurring a defect at one of the hearings. Because if you incur a defect at one of the hearings, and it has to get recalendared, we get pushed back another 4 to 6 months, potentially. So it's really important to have a perfect filing or get it perfected ahead of the hearing, and that's part of having the right person guide you through that process so that what's already a long process doesn't get pushed back even further. Another key point to this is, even though it's a very long process, if there's things like a house that has to be dealt with, it's one of the most common things in a probate is a house that we don't want to carry the mortgage, we want to get it sold. That can be done after the initial stage. So it's just a couple months, then we can deal with the assets, sell the home, whatever it may be. We just can't get to the check writing phase until the very end of the process. Now, if you'd like to discuss the specifics of your case, we do offer a free probate roadmap call directly with our attorneys to talk through what it is you're dealing with, make sure that probate is the right or only path for you, and then talk through specifics of your case to see if any of these generic timelines may tweak one way or another based on, again, what it is that you're dealing with. Of course, if you have any other questions about the San Diego probate court process or estate planning in general, always feel free to give us a call. We're here and we're happy to help.